Alabama eviction laws vary from county to county, but they still follow the same general process. You start with a clear written notice, you fill out the forms, serve the tenant, attend the trial, and then you wait for judgment. But every eviction process is different and completely dependent on the rental agreement signed by the tenant and the landlord. So it's really best to exercise meticulous file keeping to avoid errors that could be exploited by the tenant. So what I'm going to give you is a detailed summary that you can refer to when evicting a tenant. But keep in mind, I am not an attorney, this is not legal advice. Please confirm procedures with your justice court to make sure the entire process goes as smoothly as possible. So there's a couple common reasons for eviction, one of which being failure to comply with rent deadlines. A tenant's rent is late in Alabama if they have been unable to pay it for 1 day after the deadline. A grace period may be available, but only if it's stated in the lease or rental agreement. But before the landlord can start the eviction process, they are required to give the tenant an official written 7-day notice to pay. If the rent is paid within those 7 days, then the filing for eviction does not continue. However, if they are unable to pay, then the landlord reserves the right to continue filing for eviction. So the rental lease agreement has to be upheld by both the tenant and the landlord for the entire duration of the tenancy. Agreements may vary from tenant to tenant, but regardless, if the tenant violates any terms from the agreement, the landlord has to issue a 7-day notice to comply. In this case, if the tenant resolves the issues on time, the eviction process does not continue. Lease violations include things like damage to the property, smoking in non-smoking areas, or keeping pets in pet-free properties. If the violations are not resolved and they remain on the property, then yes, the landlord may continue with the eviction. It's also important to know that landlords are not legally obligated to allow the tenant to resolve the violation before presenting him with the notice to quit if the tenant commits the same violation within 6 months. So landlords reserve the right to evict tenants who have been dishonest in filling out their rental application. Examples of such dishonesty include but are not limited to the tenant's employment status, the number of people living in the unit, any personal information, or any criminal and eviction history. Any tenants that are charged with writing down false or misleading information cannot correct them. They are immediately given a 7-day notice to quit and have 7 business days to vacate the property. Now, if a tenant is engaged in illegal activity or behavior on the property, the landlord has to issue an official written 7-day notice to quit. What kind of illegal activity, you may ask? Well, let me tell you. Things like theft, violence, or assault, or the involvement in the creation, distribution, or consumption of a controlled substance, or the involvement in the creation, distribution, possession, or use of a firearm. Now, this doesn't apply in the case of self-defense, keep that in mind. Tenants that are charged with illegal behavior cannot correct them. Once again, they are given 7 business days to vacate the property after receiving the notice to quit. Alabama law takes into account the health, building, safety, and housing codes. So if a tenant violates any of these codes, the landlord has to issue a 7-day notice to comply to allow them to fix the problem. Now, there are a couple different violations under this code, but some of the more common ones include not throwing out the trash for too long, which invites bugs and rodents in, damaging electrical wiring, or ruining the plumbing fixtures of a unit. The tenant has to finish repairs or fix the problem by the end of the 7 days, and if they are unable to do so, the landlord may continue filing for eviction. In Alabama, landlords cannot evict a tenant or force them to vacate the property without probable cause. As long as the tenant does not violate any rules, they can stay until their rental period ends. But as seen in this table, if the lease agreement is categorized as monthly, the landlord may issue a 30-day notice to quit instead of a 7-day alternative. But if they stay in their rental property for even a day after their lease or rental agreement ends and have not arranged for a renewal, landlords can issue a written notice to move. Now, as far as renewal goes, if you are a tenant, keep in mind that your landlord is not obligated to remind you unless it was stated in the lease agreement. Now, before filing an eviction with the court, you need to issue the tenant a notice to comply. Now, you can find either a free PDF or Word template of this on our website, or you can use the step-by-step wizard that'll guide you through the entire process and just make sure that you are submitting the legally correct notice. Now, I will say the step-by-step wizard does ask you to pay a small fee at the end, but it's a very small price to pay to ensure legal compliance. I mean, imagine you get to the end of this process and find out you started the very first step wrong. So the eviction process can only begin after the issuance of the appropriate written notice. It is imperative that enough notice has been given before filing for the eviction. But the eviction process is pretty straightforward, and this is how it goes. You proceed to the justice court that the rental property belongs to, you file a complaint, and you pay the fees. Now, as far as the timeline for this part goes, it takes between 7 and 30 days from the issuance of the notice to vacate or quit. So an official from the court delivers the summons for the hearing and complaint to your tenant. The landlord or their lawyer is not allowed to deliver the summons. The summons and complaint has to be delivered at least 6 days before the return date of the eviction process. There are several methods available for this, first being the personal service. The court official delivers the summons and complaint to the tenant in person. Alternatively, if the tenant is unavailable, you can use what's called the substituted service, in which someone living with the tenant may receive the documents. And then there's posting and mailing. So the court official will leave a copy of the document for the tenant. It is placed in a secure and visible position by the entrance of the tenant's rented property. And then, when using this method, someone has to mail the documents through first-class mail to the tenant. So then the tenant can respond to the summons and complaint. If they do, they will receive another document stating the date of the hearing via mail. They then have 7 days to reply if the eviction process does not involve money, or 14 days if the eviction involves monetary disputes. So at this point, the document should be served to the tenant within 6 days of the process return date. You as the landlord have to provide a strong argument backed up by solid evidence against the tenant. Now, should the tenant fail to show up by the hearing, then you as the landlord will win by default. But if you don't win, you can still appeal within 7 days post-judgment for a reconsideration. Now, if the tenant replied and disagreed, in the state of Alabama, the need for a reply from the tenant for a court date to be scheduled really just depends on the county. But if the tenant files a written reply to the complaint, they must also mail it to the attorney of the landlord or to the landlord themselves. As far as the date goes, either the landlord or the tenant can both request a postponement of the hearing for 15 days. It is imperative that the landlord support the claim with evidence and show it during the hearing. Now, this includes but is not limited to things like a copy of the deed and the lease, bank receipts and ledgers, bank statements, witnesses, or photo and video documentation of the violations. And like I said, if the judge rules in favor of the tenant, then the landlord has 7 days to appeal the ruling, but, also vice versa. As far as timeline goes, there's no real clear date for when an eviction hearing has to be scheduled, but an appeal hearing has to be scheduled no longer than 60 days after either side requests it. So, provided the tenant doesn't appeal for reconsideration, a writ of execution is issued immediately. Now, this writ of execution gives the tenant a maximum of 7 days to vacate the property. So you see, the sheriff, a police officer, constable, or bailiff executes the writ. So once judgment is passed in favor of the landlord, the tenant has to move out. But only the appropriate authorities are allowed to remove the tenant by force. So even if the landlord wins the case, they are not allowed to engage in illegal methods of eviction. And if any belongings are left behind, landlords are required to store them for at least 14 days. They are advised to contact the tenant to retrieve their belongings. But after 14 days, the tenant's property may be sold or disposed of. So as far as timeline goes, the tenants have 7 days upon judgment being passed in favor of the landlord, and landlords have to wait 14 days before disposing of any personal belongings that were left behind. So here's the average timeline for a complete eviction process in Alabama. Just keep in mind, this doesn't include special cases like a request for an appeal or a continuance. So on average, it would take anywhere from 30 days to a few months to complete the eviction process. And remember, you are not allowed to be the one to evict the tenant by force. Leave that job to the authorized officials. Now, showing evidence is incredibly important, especially if the tenant disagrees with the request and they reply to the court. Keeping good records and having proof to show the judge could really be what makes or breaks your case. So how can you stay organized? So one way is keeping a physical paper trail, but this gets very hard to search through. It takes up a lot of space and things could very easily get lost, damaged, or stolen. So the next step I would say is get a scanner and scan every document into your computer. I mean, you can find a great scanner for $300 to $400 and get started today. And then, once you've scanned, back everything up on something like Dropbox or Google Drive or anything that's easily searchable, or just use a property management software. These allow you to save everything from your agreements to signed documents, invoices, payments, reminders, pictures, videos, anything that you can imagine, and anything that can help you win the case can conveniently be stored in one location. Now, if the tenant doesn't pay and they dispute the claim, it's important that you show the judge the following. Show them your lease agreement. Show them the terms of the agreement, when rent is due, and any penalties for late payments. Show them all previous payments. How were they made? Was it check, credit card, ACH, and what date were they normally paid on? Be sure to show payment returns. Did a check bounce? Did their bank have insufficient funds? Did they do a chargeback dispute on their card? Show all of this to the judge. As well, show any fees that your bank have charged you because of this and any penalties that you are now owed according to the lease agreement. And last but not least, show them your messages. If you sent your tenant automated or manual payment reminders, it's important to show this because while it's not usually required, it's still good to know that they were made aware of the situation and they were given time to cure and make a payment. This is why it's always best to have everything in writing instead of relying on face-to-face meetings and phone calls. Now, if you're evicting the tenant for a lease violation, like having a pet where you're not supposed to or property damage, it's important to show proof of that too. Now, the best way to do this is with security cameras. If you have a surveillance system that can show them actually committing the crime or the lease violation, then it's safe to say you'll probably win the dispute. If you didn't catch them in the act, the next best thing you can do is take out your phone and record a video of any damages or lease violations. And when you're done taking a video, take as many pictures as you can. Because even though you have a video, it's so important to have photo evidence, and it's usually easier to see by email or when it's printed out. No. And a landlord can actually be sued for a forceful eviction of a tenant if they skip the proper eviction process. So in the state of Alabama, tenants can sue their landlord for 3 months worth of rent or damages, whichever holds more monetary value. If the tenant chooses to terminate the lease, the landlord has to return the security deposit and any rent that was paid in advance. As another consequence of forceful eviction, there's a statute that allows tenants to stay in their property and provides the court costs and legal fees. Self-help eviction is illegal. Say it with me. Self-help eviction is illegal. Now, examples of this include but are not limited to things like cutting off the tenant's electric, water, or heat, changing locks to prevent the tenant from getting into the property, or vandalizing and destroying the tenant's property itself. And did I mention that self-help evictions are illegal, so you shouldn't do it? Thank you so much for watching. If you're going through this process, I hope that this helped clarify anything. Like I said, I am not an attorney, so if you have any questions about your case specifically, please contact somebody in your area to help you out with it. Be sure to check out this playlist where we have a bunch of other videos going over landlord-tenant laws that you should know. Subscribe if you haven't already. Thank you so much for watching, and I will see you in the next one.